it would be inappropriate for me to utter a word about tax in the presence of the Honorable Donald G.H. Bowman without acknowledgement. I don't know where to begin to speak. In fact, I had a nice little book that was dedicated to Chief Justice Bowman by the Canadian Tax Foundation with commentaries from a variety of people from both industry as well as the Justice Department and everywhere else, and quite a remarkable book. And of course, it was all about various landmark cases that Chief Justice Bowman had presided over. In due course, I'll introduce Don. I think it's sufficient to say that there's no one who has had a bigger part in shaping tax law in Canada than Chief Justice Bowman. And in due course, we'll introduce as a second part.
Yes.
I thought I would engage you a little bit, if you're okay with that. And I would ask you, and what we've done, whenever we see a trap, we kind of put it in red, right? And so I'm suggesting to you that this very common structure presents more than one problem. And I'm just wondering if we could start off by talking about that and wondering who might have who would like to identify the problem. What do you think the problem with that loan might be?
Related party loan?
It's a related party loan, yes. It's a loan from a related party, that's right, because the two companies are undoubtedly related. They're held by the same individual. Why is it a problem? Because it's a related party loan.
Is real coal used by the OPCO?
It is.
And the real estate's used by the OPCO, so it's considered active anyway, right?
Yeah, so 100% of the building is utilized by the active operating company.
I don't see any problem at all.
What are the terms of the loan?
Sorry?
What are the terms of
Oh, the terms of the loan are no interest and no specific repayment.
Payment.
Yeah,
Is that a bona fide loan then? Contractually.
possibly. Although it's not a big thing on the radar per se, so I wouldn't be overly worried about that one. But what I would say is, where does the loan appear on the financial statements?
considered active, is it?
Precisely. So it's a non-active asset. If the shareholder intends to be able to claim the capital gains exemption, he's depending upon the shares of the operating company to be a qualified small business corporation, he's going to have a problem.
Depending on the amount.
Depending on the amount. Absolutely. And we're going to assume for this purpose that it's $1 million loan. And we're going to assume that he has less than $10 million of asset. Why is it important to consider the ratio? Who can recite the regulations at 110.6?
Yeah, Tony can.
I don't even know it was 110.
50%, 90%.
Yeah, 90,
60 over
10.
24 months.
21. Perfect. 24 months.
So
50.
just one quick question.
Sure.
So even though the building is used by OPCO in its business, it's still considered a passive asset.
It is. It is.
Weird, isn't it?
Well, let's put it this way. Say it was cash, and you're saying, well, I'm going to repay the loan. Well, obviously, cash is a non-active asset. Loans to related parties are on the radar. So could you argue it? Of course you could. And you know what? We'd help you argue that, by the way. It's not something I'd prefer to argue. I'd prefer not to have to deal with it. But we're seeing CRA being very diligent. It's getting to the point where it's really difficult to reason with some people at CRA. And I've had that discussion with Tony as well, and Dominic too.
Sorry, they're looking at it specifically for the small business exemption or something else?
Yeah, so there's two court cases recently that talk about non-active asset. One is a Supreme Court of Canada decision, and the other is a Tax Court of Canada decision. And to be honest with you, I don't think either one is good for business owners of CCPCs. Both of them essentially say the same thing, well, a little bit differently. They both say that assets that are held by a corporation have to is critical to the company's survival. The Supreme Court of Canada decision states that the funds would have to be a mandatory precedent to trade, meaning you cannot run your business without those funds, those assets, the cash, whatever it happens to be. The other decision is a Tax Court of Canada decision that stated that the withdrawal of the funds would have to have a decidedly destabilizing effect on the corporation, meaning that you just wouldn't be able to run your company. And I think it's pretty, severe, But obviously we're interpreting the law. We don't make the law, and neither do you. But we certainly can help to navigate to prevent against an issue where a capital gains exemption is denied. Particularly when you see what people do when it's money that's being, please.
So before the loan, wouldn't the company already still not meet the test because it had the cash sitting there?
Well, that's right. The cash is a problem too. Cash is never good. We've seen situations where someone has parked $50,000 overnight in a company and CRA's challenged it. All right? Yeah. So well, the rules at the time of the sale of the shares, all or substantially all. Isn't that correct?
Yes.
All or substantially all of the assets have to be actively used. So what is 50,000? If there's less than $500,000 of assets in the company, you're offside. So I think it's got to be on the radar. It's on CRA's radar, right? So I think as tax practitioners, we all have to be mindful of companies who are at some risk.